Hello. You're either watching or listening to Think Resolutions, which is my podcast. My name is Howard F. Kline. I've been a California licensed attorney for now 47 years, and I'm currently a mediator and arbitrator. Today, this podcast, we're going to be discussing the Pre-Mediation Conference. My special guest is Nelson Edward Timken. Now, let me tell you a little bit about Edward, or I should ask, and maybe it should it's either Nelson or Edward. I'll ask him how he wants me to address him. In any event, Mr. Timken is currently a mediator and arbitrator and was a principal law clerk for the New York State court system for 29 years. He practices as a mediator and arbitrator, both New York, and is a Florida certified circuit civil mediator. If you're watching this, you can see the link to his website where you can get more information about Nelson. Now let's move on to the cast. Nelson, how should I refer to you? Nelson or Edward?
Either way is fine. Just don't call me late for dinner.
I say lunch. There you go. All right. So, Nelson, I'll call you Nelson. Let me ask you the first question. What is a pre-mediation conference?
It's a preliminary meeting between the parties, generally the attorneys only, but sometimes the parties are also included, to try to get enough information about a dispute and the parties involved in the dispute in order to streamline the mediation.
Now, that's your purpose. So let's talk about that. What is it that you're looking to accomplish by a pre-mediation conference?
I want to prevent surprises during the mediation in terms of what the dispute is about, in terms of what the parties are like, what their relationship is, what they're looking for, their goals and expectations. That's what I want to do. I want to prevent surprise.
Why?
Why? Because when you're in the middle of the mediation and you find out that you don't have the right person there who's authorized to enter into a settlement, that is one thing that can render the mediation ineffectual. When you don't know enough about the parties and their relationship, that's another thing that can mess up the mediation and render it ineffectual. You want to excise from the situation anything that could potentially interfere with the chance of settling the case.
Why is it important to make sure that you have the right parties in the mediation?
Because without the right parties, if you don't have somebody who's authorized to enter into a binding settlement, you've just wasted your time. You need to have either the right party on hand or on telephone contact so that you can, if there's an offer, you want to be able to contact the person who can say yes.
Okay, so that's a good start. Do we have the right parties to the mediation? Because if you don't, then if you reach an agreement, it's not enforceable.
Right.
Okay.
You want to have
D-
somebody who can sign the stipulation or the memorandum of understanding.
So, what are the other things that you find are important to clarify? Why don't I put it this way? In the initially using that to clarify the game. Here are the rules of the game. Why don't you
Right.
tell us your checklist and what you go through?
I want to find out a little bit about the dispute from the parties' perspectives, from the attorney's perspectives. I want to find out what their goals are for the mediation. I want to find out a little bit about the logistics. I want to find out what style of mediation they would prefer me to do, knowing that there are a few different styles. Many of the attorneys know this, and they may say to you, if you have a suggestion or if you want to bring up some options, we would appreciate that. I want to know if there's any discovery that they don't have that they are going to need in order to intelligently think about resolving the case. If they don't have the discovery they need, then we're also wasting our time doing a mediation because it's premature.
For the
I also,
non-lawyers out there, explain what discovery is and
Mhm.
why it's important for you to know the state of discovery at the time of the pre-mediation conference.
Discovery is information exchange between the parties regarding the dispute. And it's important to know what they have and what they're looking for because they have to know what the other side's position is, what the other side's possible defenses are, if they're supported by the documentation. The commercial case, the documentation is very important. And they need to have the documentation, any bills, invoices, contracts, anything that basically supports one side or another. They've got to have that before they go into the mediation.
Why?
I generally, why? Because they don't know if they have the smoking gun to support their case or not until they see what the paperwork is that's involved. There may be documents that the other side has that they were never given, and they
Well, if the
also want to
mediation
know
is
that.
not, it's not a trial. It's not a
No,
question of proving or not proving something. So let's dive into the weeds a bit as to why it's important for either the parties or you to know what information they have or what information they don't have that maybe they should have.
they need to know the strength of their case on the paperwork.
And
That's one
why's
thing,
that?
because negotiations are all about strengths and weaknesses. And you need to know what your chances are should you take the case to trial. That is what we call BATNA, the best alternative to a mediated agreement, which means basically that what is the likely outcome if you don't resolve this case at mediation? And you also have to know what's called the WATNA, WATNA, which is the worst alternative to a mediation agreement. If the chances look pretty slim at trial, then you certainly would be justified in trying to resolve it now. And the
How
paperwork,
important how important is for you to know the whatnot and botna versus how important is it for the attorneys to know the botna and whatnot?
in the facilitative trial, in the facilitative style, rather, it's not really that important for me to know because what I generally do is I'll ask them what they believe their chances are privately in a caucus, what their chances are if they take the case to trial. That's one of the things that I will ask them. And hopefully I'll get a realistic answer. One of the other things I try to do at the pre-mediation conference is to ask them to be open with me and tell me what they honestly feel the situation will be, because it's to their benefit. Nobody wants to take the case all the way and lose, because the client could very well blame the attorney and sometimes does.
Yeah.
So you want to do what's good for the client, and you may have to convince the client of that. But at least if you have the information, you're armed with the knowledge that you need.
How important is it for you to know how experienced the party is, both in the process, the mediation process, and the subject? Actually,
It
this is a threefold question. Why
right.
don't we start out with how important is for you to know how knowledgeable the parties are and the attorney is with regard to the mediation process? And is this something that you tried to establish at the time of the pre-mediation conference?
I'll answer the last thing first. I I don't try to establish that at the time of the pre-mediation conference, but it's somewhat important to know how experienced they are, because it often does give you information about how cogent their opinions are of the strengths of their cases. If somebody is practicing out of their normal practice area, which happens, and they insist that they're going to win the case, then internally, I would feel that their opinion is less likely to be correct than somebody who's in the trenches with these cases every day, assuming the person is candid about their chances.
I want to get to something. How important is it for now let's assume for the moment that this is a pro per or a pro se party without an attorney. How important is it for them to know their level of experience in litigation or mediation?
It's important for them to know it, but I find that many times the pro se person is out of touch with their own limitations. And that's one of the pitfalls of dealing with a pro se individual. They think that they can't lose, and they really don't have the information they need in order to properly evaluate their chances. Or they've
As a,
read a few things and not everything.
as a mediator, do you make any effort to have them recognize their limitations?
I make a gentle effort when we're in caucus. I try to make them understand that when a layperson is up against an attorney, the attorney is skilled and trained to defend the case or to prosecute the case, and that works a handicap against them. But as I said many times, and this is why people don't like to do pro se cases, many times they are convinced that they're going to win, irrespective of what the reality of the situation is.
I'd like to step in a little bit on this uh, because I've handled quite a few pro se mediations. And it's not uncommon to be in the situation where both sides do not have an attorney. Let me give you a perfect example because I'm very much in the world of commercial leasing. And I've handled a number of mediations where the landlord is represented by a property manager who's handled hundreds of eviction cases or hundreds of collection cases or hundreds of mediations. And when they tell me that they're confident that they're going to be successful, as a mediator, I always take that with a certain grain of salt. But I would tend to give greater credence to a property manager who's got tons and tons of experience in court versus a tenant who's never been to court. And as you say, invariably, that tenant will say that they're absolutely certain that the judge is going to rule in their favor, which is scary because, as I've said before, I've been an attorney and have done hundreds, if not thousands, of lawsuits, and I never know. It's scary walking into court, as certain as I am. You never know how the court's going to rule. And it's even worse if it's in front of a jury.
There's a sympathy factor, which the pro se has, which the commercial landlord does not have.
Oh, gosh,
And,
yes.
and that's the X factor in the dispute. The judge may see the person and feel really sorry for them that they're losing their business and about to be thrown out. And as many judges, I'm in New York, but many judges do see things that way. The person is going to lose their business. They're going to be put out. And geez, let's give them a little more time before we do that. So that's the factor that may make the property manager wrong in his or her opinion.
Yes, I think it does make a difference. If you talk about the sympathy factor, whether it's a lawsuit for any reason, not just an eviction, between a landlord and tenant, if you go in front of a jury, there's always that sympathy factor because more jurors have been in the shoes of a tenant, not necessarily one who's been evicted or is not having money, but they can more easily relate to being a tenant than they can a landlord. So, from the landlord's perspective, you really don't want to go in front of a jury if you can avoid it, which is why a landlord would want to mediate or even arbitrate.
Yeah, there's a mercy factor that comes into play, and that can turn you from a winner on paper into a loser in reality in those cases. So that's why my experience in those cases when I was in the court is they invariably involve a waiver of rent in order to secure a judgment of possession. That's how we do it here in New York. The landlord has to be willing to waive the rent to get the tenant to voluntarily leave.
Now, let's talk about other points that you want to make sure in a pre-mediation conference that the parties understand that that if they understand increases the benefits of a mediation.
I want to make sure to learn about the dynamics between the parties and sometimes also the lawyers. I want to make sure that the parties are not going to come to the mediation and just yell at each other. I want to make sure that they're going to be civil within the context of the mediation, that they are going to respect one another, let each other talk, and listen to what the other party has to say. I want to know if there's a power imbalance. Um, I want to know if the lawyers are getting along. I want to know if the lawyers are going to be willing to give me any insights as to the personalities of their client. Sometimes you'll get that. The lawyer will say, my client's a pretty tough guy. And you're going to have some trouble with him if you do X, Y, and Z, so that I can make sure not to do X, Y, and Z and create an unfriendly or hostile situation. I want to find out some nuts and bolts things. Where do they want to hold the mediation and when and who's going to be there? And do they want to submit a pre-mediation brief? And if they submit it, do they want it to be confidential or do they want to share it with the other side? And if they don't want to share it with the other side, are they willing to submit two pre statements, one that they give me only and one that they share with the other side? I think it's always good to share your pre-mediation statement with the other side because you are telling the other side what your position is. And hopefully they read it and think about it. That's the purpose of the mediation, is to allow the people to communicate with one another and maybe even to consider the other side's position. So those, I think, are among the things that I want to find out. I want to find out why they're conducting the mediation. What do you hope to achieve? Do you want to start the ball rolling so that there can be a continuation of communication between the parties? Do you want to try to resolve it at the mediation right then and there? What is it you're really looking for?
Let's talk
So
a little bit about not so much what you want to find out, but what not just the game plan, but how the game is played, specifically privacy and confidentiality. And this may vary from organization that's conducting under what rules or what state or what jurisdiction. They,
right.
how do you like to operate and what do you tell them about privacy and confidentiality?
I tell them that under normal circumstances, everything that's said at the mediation, including the caucuses, is private and confidential, and that they can't call me as a witness to a later trial, and they can't utilize anything that was said by the other side as a party admission, anything like that. In Florida, that's covered under a law. In New York, it's not, but the idea is the same. There are only exceptions when there is uh, a suspicion of child abuse or physical harm to one of the parties. Those are the only standard exceptions that you see. So I tell them that everything that's said is private and confidential in the mediations and goes no further. Are there cases where the courts have asked the mediator to disclose what happened? Yes, there are. Do I tell them about those cases? No, I don't, because those are few and far between, and those are very high standards that the court has generally imposed in order to have a mediator talk about what happened at the mediation.
Why
Does
is
that
it
answer your
important?
question?
Yeah, to the mediator, it's important that the parties understand that you're not going to be in the position, except in very rare cases, to disclose anything that was discussed during the mediation. That's different from what the parties discuss. So I
Right,
think more universally, it is that the mediator, I don't know if it's in very state, but I would imagine so, that the mediator is protected from being forced to disclose what was discussed with some exceptions. For example, in here in Nevada, where I live, child abuse, spousal abuse, animal abuse are things that if it's disclosed as a mediator, that's not private and confidential, and I may have to disclose it, most likely. But why is it important that the parties understand that what they discuss during the mediation should remain private and confidential?
So that they'll be honest with me and tell me things that they don't want the other side to hear and they don't want to come out in court, so that they will be totally honest with me about what the circumstances are, about what their expectations are, about what they'll be happy to achieve, things that you don't want the other side to know.
But that's only in the caucus, and that's your responsibility to not disclose things. But sometimes in an open discussion during mediation, because you really want the parties to talk to each other, that's the preferable way of going. They're going to say some things that they don't want to be used against them in a trial or an
Right,
arbitration.
right.
So I think that it's important that they understand that the other party can't go into court and say, you said this in the mediation, and therefore it contradicts your testimony at the time of trial. But that doesn't prevent the cat from getting out of the bag.
You want them to be comfortable about the fact that what they're talking about is going to stay within the mediation setting. And in fact, when I do a caucus, I tell them that I'm not going to tell the other side anything that they tell me in the caucus unless they authorize me to do so. In Florida, they don't do it that way. They put the onus on the parties to tell them if there's anything that they would rather I not tell them. And I don't really like that way of doing things. I would rather get explicit permission to disclose something than have them say a whole bunch of things and put the onus on them to tell me they don't want the other side to hear that.
Uh,
So it does
Yeah,
differ.
yeah, I agree with you. And I don't practice in Florida, but even if I did at a pre-mediation conference, I would tell people up front during a caucus, I am not going to disclose what you've discussed with me unless you've authorized me to do it. So the people understand that. And that way I'm more and they're more, I believe that's a more comfortable way of dealing with it. And I just had that conversation is what should you do here in Nevada? And as I said in my pre mediation conference, this is how I handle things. If you tell me now you don't want me to handle things that way, please make sure that you let me know. Now, even in a shuttle mediation, which just had a shuttle on a TPO last week, you're it was in person, which doesn't happen often with me, but you got to go as the mediator, you got to go back and forth and communicate what the other parties are saying. So that's handled a little bit differently. But yeah, those are things that has to be very clear. And the pre-mediation conference is where you get to do that.
I also tell them what my standard practice is
Yeah.
for conducting it and ask them if they would like me to divert from that standard practice. In other words, I generally do a joint session to begin with. And after they do their opening statements at a joint session, then we go into caucus. But some people don't want a joint session at all. They just want to start talking about numbers. And if that's their preference, then I can do that. But I think personally, I think mediation is all about listening to the other side. If you don't want to hear their statement, I think it's going to be more difficult to settle the case. That's just my particular feeling. I think you want to hear what the other side has to say. And I don't, I usually don't say, would you give your opening statement? What I generally say to them is, what is this case about from your perspective? So that they're not constrained to tell their whole story. Or God forbid, and I've seen this happen and had this happen, God forbid an attorney has a pre-prepared statement and just reads from it. I really want the parties to talk about what is important to them in this scenario. What are their interests? What are you really looking for in this particular scenario? What is it that has you disturbed about it? And I would like to focus on that so that the other side hears it. And then I can amplify it by reframing it. And then it's hopefully gotten through to them by then, by the time we get into the caucus. That's my general modus operandi. But I'm willing to change it if they want to just start bandying numbers around.
Yeah, that,
It's their procedure. It's their proceeding, not mine.
yes, and you're there to help people get to some sort of agreement that they've bought into, and hopefully they think that they've created.
Right.
Uh, there's one additional thing there's probably a number of other, but there's one additional thing that I'd like to have clarified because I do both facilitative and advisory mediations. When two attorneys are involved, it tends to be advisory. You know, the attorneys are looking for some sort of support from a neutral to tell either the other side or their client that a settlement is a good idea. Facilitative is a little bit different, where we don't really make suggestions, we don't give our opinion of the case, etc. And I think it's important to know that before you get into the mediation. What are your thoughts on that?
They teach everybody to use a facilitative method here in New York and also in Florida as well. But the reality is, when you get into the actual mediation with many attorneys, they really want you to help them come up with options that the client can accept. And so you're called upon really to come up with ideas and to be an idea person. And it does become more, instead of evaluative, I would say more advisory or active on the part of the mediator. And really the other thing is, it depends on the cause of action. In some courses of action, you almost have to be advisory if you want to settle the case. If you're handling a wage and employment dispute, and the employer is scoffing at settling the case, I think, frankly, you're really doing them a disservice not to let them know that, or at least ask them or ask their attorney to tell them privately that there are statutory fines that are applicable before they even get to compensation for the employee. They're going to be subject, at least in New York, to statutory fines and penalties that could be as high as $10,000 before they even take a look at what the person is actually owed. I think they have to know that. In a divorce case, which I don't do divorces, but many people tell me that they are far more not evaluative, but advisory in a divorce case because the people have to understand that a divorce where there are children involved is not a permanent isolation from all contact with the other side. You're going to have to co-parent. You're going to have to get along with the other side in order to do that. And unless you want to be back in court all the time and have to pay your lawyer a lot of money to go to court to work out the co-parenting agreement, it really behooves you and your ex to get on the same page and work things out with a mediator.
In a facilitative, I try really hard not to tell them what's going to happen in court. And I, it really is up to the parties whether or not they want an evaluative or advisory or facilitative mediation. But if it's facilitative, I try really hard not to, and I'll use the term directly make suggestions or directly tell them what's going to happen in court or directly tell them what the law is. I use a method that I call benevolent manipulation, where I may just ask if there are any fees or penalties. And even then, when I ask that question, if they're attorneys, I'm a little bit more comfortable. If there are parties, I'm a little bit uncomfortable even asking that question because it may be perceived that I'm putting my finger on the scale. And that's really important in a mediation not to do.
But if the attorney comes back and says to you, it's no problem, Mr. Kline, we'll deal with it, doesn't basically play the game of taking your clue and using that as the opportunity to say to the client, Mr. Kline's right. This is going to cost us if we keep going. Or if the attorney says to the client, don't worry, we're going to kick ass in court. Because the reality is that the attorney makes money litigating. And sometimes the attorney is cognizant of the savings to the client of doing the mediation, but sometimes the attorney wants to litigate it for various reasons. And if they don't take up, as I said, if they don't take the hint from what you're saying, because I've done the same technique and said to them, are you aware of any penalties in cases of this type? And if the lawyer says, don't worry about that, Mr. Kline, we'll deal with it. What do you do there? Then you're put in a situation where you either don't do anything, which is what you're probably supposed to do, but then you're really not helping the person in the end analysis because they're going to be subject to this situation. I don't know. It's a tough question, and it's an ethical question as to how far you go.
Sure, I'm a believer in you can lead a horse to water, but you can't make him drink. I'll take the water and splash it on their face. I might push their head down to the water and go, come on, you gotta drink. But if they're not gonna drink, they're not gonna drink. And I might be a little bit disappointed, but I'm not gonna torture myself over it.
You
You
have
know,
to just accept it for what it is, and that's it, and move on to the next one and
yeah.
understand that
And and
it's
I
a
think
difficult
as a
situation.
mediator, our skill really comes down to our ability to understand the parties, understand the issues, understand the attorneys, and use our skills to lead them to their own resolution and to then get frustrated and say, I'm just going to tell you, give you the suggestion. So you can be sitting in a brainstorming session and get people to come up with ideas on their own because it's my understanding that the more people believe that they came up with the resolution, the more likely the resolution will be a good resolution.
Also, a lot depends upon how familiar you are with, for example, the attorney. If you've worked with the attorney before and the attorney trusts you, that makes the situation a lot easier because you can say to the attorney, listen, Howard, how likely do you think it is that you're going to win this one at trial? And if you have an attorney who's honest and says probably about 40% likely, that makes your job as a mediator a lot easier. Obviously, this happens in caucus, but here you have somebody who's leveled with you and he's willing to accept that he's got a tough row to hoe. And that makes your situation a lot easier. You don't have to ask those splashing the water on their face questions because he already knows what the situation is. And no attorney wants the client to blame them for losing a case. And attorneys don't want to lose the case if they can help it. So I think that helps you. You can also do what I've seen some people do who have numerous repeat clients in terms of the attorneys, and that is they engage in a technique known as confidential listening. If the person really trusts you, you can engage in confidential listening where the parties tell you right up front what they're looking to walk away with. And you as the mediator can figure out how close they are and if it's worthwhile to continue or not. That saves the parties a lot of money. If you trust each other and they tell you, look, we're looking to get this and they end up being $100,000 or $200,000 apart, then there's no way that you can usually breach that amount of a gap. But as I said, trust is everything. They have to know you, you have to know them, and you have to trust each other.
And it's important for the mediator that both parties trust you
Right.
because if they don't, then you no longer seem like a neutral. And again, perception is as important, if not more important, than anything else. I'm going to have to wrap this up. Nelson, I'd like to thank you for
You're
participating.
very welcome.
I'll let you know as soon as this becomes available. Would you like to let everyone know how to get a hold of you?
Absolutely. Just shout very loud. No. My email address is Nelson at timkendisputeresolution.com, or you can call me at 917-533-8080. And email is generally the best way to do it. I return emails very quickly.
Great. And if anybody would like to get a hold of me, my email is howard at TEGADR.com. And my office number is 702 706 4433. All right. And thank you very much, Nelson. And you have a great day.
You too, Howard. Be well.
You too. Bye bye.